The Cabrini Green Project is what public housing has come to symbolize in Chicago for more than a quarter of a century. But in an effort to disperse the city's poor, who are mostly black, the new public housing proposals call for construction of duplexes, two-story townhouses, three-story apartment buildings, all to be scattered in the predominantly white areas of Chicago. This lot on Comiskey Avenue is one of 275 sites identified under federal court order by the Chicago Housing Authority for low-income families. It would have a duplex on a street of single-family homes, and the homeowners are obviously upset.
All I got to say is, all the do-gooders, all the people that are always telling us what to do, they don't practice what they preach. Why don't they go over there and put them by their neighborhoods? They won't do it. They're always telling us what to do. After all, we have a few rights of our own, too.
Well, it's going to bring down the value of everybody's property.
Why do you think that?
Because, well, I don't know why. You see those other projects they have, and they don't take care of them.
Where we're going to go, tell me. You have to stay. If you're going to go there, they're going to go there, too. They might as well get used to them and live with them. What else can you say?
The City Council, acting under orders of Mayor Richard Daley, voted to pigeonhole consideration of the housing problem until after April 6th, when Daley seeks re-election to his fifth term. The mayor made it clear he opposes federally financed public housing and will substitute it shortly with a plan of his own.
The inability under the court order to build low-rise public housing where the need is greatest, the failure to include the resources of the suburban areas in sharing responsibilities for housing, and the contradictory national policies. These reasons have led me to conclude that the public housing proposal of last Friday is, under these conditions, detrimental to all of the people of Chicago. And in my opinion, these units should not be built.
If the mayor of this city indicated to his constituency that we must have housing for all of the people, and it will be for the betterment of all of the city of Chicago, at least you would have a visible leader putting himself and his position and his prestige on the line for proper housing for all of the citizens of Chicago. At least you wouldn't then have policemen and irate white citizens saying to themselves, well, the mayor's not for it either. Therefore, we can throw bricks, we can set fires, we can burn crosses, we can curse, we can be profane.
A few days ago, no one on Comiskey Avenue paid much attention to this vacant lot. But its selection as a future site of public housing has turned all eyes this way. There is more concern than anger among the residents, concern over whether they'll be able to sell their homes. For laws or no laws, they are not inclined to live in a changing neighborhood. They will run as others before them have run, if they can. Murray Fromson, CBS News, Chicago.
35 miles separate Chicago from Stateville Prison at Joliet. John Edmonds traveled that distance in July of 1962. When he arrived here, however, he was not at the end of his journey. Convicted of rape, he still had 50 years and a day to go. And that was as hard for him to believe as it was easy for a jury to believe him guilty. For the next year, Edmonds devoted his spare moments to the reading of law books, a prisoner pastime with a high priority. He wanted to learn how to file an appeal writ. Other inmates, convinced of his innocence, offered their help even at the risk of solitary confinement. Pieces of paper containing portions of the legal form were smuggled to him. One prisoner drew 15 days isolation for helping to draft the form. Edmonds himself was given similar punishment for having a scrap of the document on his person. Today, inmates are no longer restricted from assisting others in the preparation of legal papers. On June 2, 1964, still in custody, he was returned to Chicago for a new trial. His appeal had been successful. His conviction by an all-white jury had been overturned. Unable to raise sufficient cash to bond himself free, Edmonds remained a prisoner at county jail for another 12 months, waiting for a new trial. After nearly 4 years' confinement, his bond was reduced from $60,000 to $1,500. With the help of his family, he raised the $150 that allowed him to go home for the first time since his arrest. Then came the second trial and a second chance to plead his innocence. Again, for a criminal court's jury, he remembered aloud the night of his arrest, March 9th, 1962. He related how he left his apartment at 1637 Dayton Street and walked in the direction of a tavern on North Avenue to make a purchase for his wife. To reenact the sequence of his movements, Edmonds revisited his old neighborhood this week for WBBM television. He had not seen the area since he was abruptly whisked away from it in a police car 9 years ago. Vividly remembering his arrest, he detailed how a squad car followed him as he walked from the alley back of his apartment into the parking lot of the Dell Farm Market on Halstead Street. He told of being stopped, searched, and beaten, then arrested. Later he learned he was charged with the rape of a 71-year-old white woman, a woman who told police she was drunk that night and couldn't remember who attacked her. Edmund's second trial ended with a hung jury, but his third appearance before a judge and jury, this time in the Civic Center courtroom 2 years ago, was different. This time his lawyer, a public defender, believed him. That attorney, Sheldon Banks, is now in private law practice.
Mr. Banks, what convinced you, when you were a public defender examining the case of John Edmonds, that he was innocent?
The police officers in this case alleged that Mr. Edmonds ran out of the home of the woman that he was accused of raping, and they chased him for a period of time. We all know that because of John's condition, he has a frozen leg, that it was a physical impossibility for John to do this. I think that this was the basic reason that I was able to convince the jury that John was innocent of this charge.
Even though Edmonds was found not guilty, the state refuses to compensate him for the time he spent in jail. The law says restitution for wrongful imprisonment must be requested within 2 years after release from prison. Edmonds could not make such a claim until he was declared innocent, and that came 4 years after his release from custody. 43 years old now and a grandfather, he finds it impossible to obtain work because his record shows a conviction for rape, and that's all employment people apparently see.
What is it you want from the state? Is it money? Is it a pardon? What is necessary to put your life straight again, sir?
Well, I feel that I should have something that would show the entire public that I was not guilty of the charge of rape. I feel that the state made a terrible mistake in convicting me of a crime, robbing me of every little self-respect that I had. I feel that they should pay me for my labor that was performed in the state penitentiary, and for all the hardship that I suffered while I was there, the lack of medical attention. And I think that they should reimburse me for everything that I lost because I wasn't guilty.
How about a pardon, sir?
Well, I think that if they are going to in any way give me anything at all, they would have to give me a pardon. I believe they should, and I believe know that they should give me a pardon. I wish they would. I need it. It's very important for me to go on in life. I should have something to verify that it was all a mistake.
Through a special act of the state legislature, Edmonds could be compensated for his years in prison. The man who won him an acquittal is working on that possibility.
That alley there up to here took 7 long years out of my life.
Then again, can he ever be compensated for what's happened to him? Harry Porterfield, Channel 2 News.